to get retroactive CLE credit, but I will keep you all posted. So our first speaker today will be Andrea Mosley. Andrea is the managing attorney of the Fair Housing Program at Community Legal Services in Mid-Florida, and she has been litigating cases in the consumer housing and fair housing units for the past 6 years. Prior to her time at CLSMF, Andrea was a solo practitioner for several years and an assistant public defender for the Ninth Judicial Circuit. I'm doing abbreviated bios, but they are in your handouts, the more detailed ones. We will also have Katherine Hanson joining us today. Katherine is a senior staff attorney with Disability Rights Florida, where she focuses her practice on disability rights and housing law. Prior to joining Disability Rights Florida, Katherine was the co-director of Jacksonville Area Legal Aid's Fair Housing Unit, where she practiced fair housing, landlord, tenant, and consumer law. Katherine was a 2018 recipient of the National Consumer Law Center's Rising Star Award. And lastly, joining us from the Department of Housing and Urban Development in Atlanta will be James Baracall Jr. James is a retiree of the United States Navy with a prestigious career of 26 years. He joined the Department of Housing and Urban Development in 2017 as a bilingual intake analyst. He is considered a subject matter expert in the processing of Spanish limited English proficiency claims. And he is located in Atlanta, Georgia. So thank you all for joining us. Everyone is muted. So please, if you have questions, we have a lot of attendees today, so make sure you type it in the question box or the chat box on the right-hand side. And I will turn this over to Andrea to get us started off with her presentation about reasonable accommodations. All right. Oh, let me make sure we've got the sound on for you, Andrea. I don't hear you. Okay, there's your sound. Sorry about that.
Oh, okay. Sorry. Most people prefer me muted anyway. So.
No way.
Good morning, everyone. As Christy said, I am the Fair Housing Manager, one of two at Community Legal Services. And this webinar started as, a COVID idea. I was at home feeling stir crazy, and I was like, hey, let's have a webinar. So I called the smartest people I know and asked them if they would help, and they all said yes. So I would like to thank all of them for saying yes and being willing to participate. We all have caseloads, and coming up with this presentation, I was doing it until last night. So please forgive me if I spelled something wrong or slipped in a picture of my dog. It was unintentional. Okay, you ready to go?
I'm just showing my screen right now. Make sure we got it. All right, can everyone see my screen? All right, we're ready to go.
Thank you. All right, so I like to have my fellow lawyers refer to me as Dr. Mosley because I think it's hilarious. So I put Dr. Mosley on everything. So when you ask your questions, kindly say, Dr. Mosley, I have a question. No? Okay. So I thought we would start with a very fast, super quick, really quick Fair Housing 101. This is not meant to be a Fair Housing 101 webinar. We're going to dive deeper into specific subjects, but I thought it would be helpful just to do a very quick touch on the things that would help you throughout the presentation. So next slide. In the next slide are the protected classes, in case you did not know them. For reasonable accommodations, we're going to be focusing on one particular protected class. On the next slide, you will see what actions are prohibited by the Fair Housing Act. And on the screen, on the slide that follows, you will see housing providers not covered under the Fair Housing Act. So who is covered? Everyone who's not listed here. Okay, so that's your Fair Housing 101 review. Any questions before I move forward? No? All right. So as part of fair housing, and anyone who practices fair housing will tell you that fair housing and landlord-tenant are often intertwined, and clients will have one problem, one of either problem, and end up with both. So a housing practitioner should be able to issue spot in each area. We're on to the next slide now. Your client may come to you on a notice to terminate, and their concern is that a eviction has been filed or will be filed, and they're not aware or even able to communicate with you that they would benefit from a reasonable accommodation because they may not know. And a reasonable accommodation request or an RA can be sent in response to notices. And an RA can be filed while an eviction is pending. Now, with the new HUD opinion, they say there's an inference of bad faith, but I don't care. You can still do it. And opposing counsel will be upset, and that is their problem. They still have to consider your reasonable accommodation request, and the new guidelines say it needs to be done within 10 days. So there are some things you can do with opposing counsel when you send a reasonable accommodation request in the middle of eviction. Usually you would ask for a continuance because by federal law, they are required to consider your reasonable accommodation request. And we all know that federal law trumps state law. Opposing counsel will usually want to have a settlement agreement, and particular opposing counsels favor particular clauses. Just remember that a probationary period or automatic defaults are not in your client's best interest if your client is disabled, especially automatic defaults. If someone is disabled and it's a mental disability, they could default without intentionally defaulting. So please be aware of that, and do your best to not agree with those. Next slide. When you are evaluating landlord-tenant cases for fair housing issues, you should always ask yourself, what is the issue? Can the issue be addressed or resolved with a reasonable accommodation request? Does the housing provider fall under the Act? Is the tenant still in possession? And is there a disability nexus need? Also remember that there is such a thing as a compulsory counterclaim. So if the eviction has arose because of a disability related issue, and the housing provider has failed to grant an accommodation, anything like that, that is a compulsory counterclaim, and it must be filed with the eviction or you waive it. Typically, you have a right to go to federal court for these claims, but I have not been able to find a case that did not say it wasn't a compulsory counterclaim, and the federal court will kick you back to state court. Reasonable accommodations and landlord-tenant. So I've given you some examples of when you would have a landlord-tenant case and you could possibly have a solution with a reasonable accommodation request. Noise complaints. So someone may have a mental health issue, which causes them to scream at night. They may have a child who is autistic, or someone may have PTSD. Unauthorized occupants, again, a mental health issue, or they may have someone basically acting as a live-in aid, but have never notified anyone of it. Violation of a no pet policy, that's an emotional support animal. Multiple police visits could come for many reasons, not just mental health, autism, PTSD. It could also come from domestic violence situations, which wouldn't be south of the RA, but just be aware. Failure to maintain the property, that could be because your client has a physical disability and can't do it on their own, or need more time to comply than what was given in the notice, or the person has mental health issues. Again, dirty houses, hoarders, physical disabilities, parking spaces, smoking violations. So medical marijuana, that is a fun one, and it's an emerging issue. So when we are dealing with medical marijuana, I have a question for you all. You all up for a question? Because it's early and I would like you all to wake up. What do you think? All right, so we have a client, and let's say, just for, I'm just going to pull this out of my hat. Lizzie is our client, and Lizzie lives in public housing, and Lizzie has a prescription for medical marijuana, which is now legal. And Lizzie would like an accommodation of the rules to allow her to smoke her medical marijuana. Is Lizzie allowed to have her medical marijuana? Who thinks she is?
We have a couple of votes for no, Andrea.
All right. Any votes for yes?
Not yet.
You guys are no fun. You already know the answer. No, she is not. And the answer is why? Why? Why can't she? For anyone who said no, why can't she? And I cannot see any responses, so.
Okay, so we have a kind of a question. Did she request reasonable accommodation?
Yes, she did.
Okay, the second comment is HUD guidance allows the landlord to make that determination. Property owner's rights, not considered a medication under federal law. A lot of people, it is against federal law.
And that is the answer. It is against federal law. Even if medical marijuana is legal in your particular state or city or county, it is still illegal federally. So please be aware before you send out a reasonable accommodation request for medical marijuana and someone lives in subsidized or public housing. You will not succeed on that ground. Okay, next slide. All right, we're going to talk about reasonable accommodations and modifications. What is a reasonable accommodation request? Well, it is a request for an exemption, adjustment of the rules, policies, practices, and services under Section 504 of a housing provider to give a disabled person equal opportunity to use and enjoy the dwelling. We're on the next slide. So, for example, you will have a no pet policy or a no dog policy or no dog over 50 pounds policy. All those things are subject to emotional support animal or service animal exemption. If you have paid parking spots or no assigned parking, that is also a reasonable accommodation request. Next slide. There is a joint statement from HUD in regards to reasonable accommodation requests, which will either, you can either see or access on the Google Drive. I could technically spend an hour talking about every joint statement. I'm going to refer to an hour on each statement, but you guys would not enjoy an 8-hour day of me going through HUD opinions. So I'm just referencing them and supplying them to you so that you can read them on your own. If you're going to practice fair housing, you should read them and be aware of them when they come out. So that's the first one. That's in regards to reasonable accommodation. Next slide. So what is needed for a reasonable accommodation request? Well, I tried to break it down into 3 simple words. I was trying to make it come up with a, a nice mnemonic like Dan or something, but I couldn't do it. So disability, nexus, and need, right? And necessity. So for everything, you have to be disabled. If you're not disabled, you do not fall under the Fair Housing Act. There has to be a nexus, which is a connection between your disability and what you are requesting. And it has to be a necessity in that it alleviates one or more, alleviates or mitigates one or more symptoms of your disability. So keep that in mind as you evaluate accommodation requests and going forward, because I may ask a question. You never know. All right, so what is disability? Next slide. Disability is a physical or mental impairment that substantially limits one or more major life activities. Individuals are regarded as having such an impairment, or individuals with a record of such an impairment. We're on the next slide, Christy. So the definition of a major life activity is seeing, hearing, walking, breathing. Oops, you went too far. Seeing, walking, breathing, caring for yourself, learning, speaking, performing manual tasks. So any disability that would necessarily involve those things is a disability. So it wouldn't be hard to know that if it involves seeing, if you're blind, you're disabled. If it involves hearing and you're deaf, you're disabled, right? And so if you're in a wheelchair and you cannot walk, you're disabled. So following along with that, on the next slide, the ADA has several recognized conditions, which are disabilities, deafness or blindness, intellectual disabilities, autism, HIV, traumatic brain injury, cerebral palsy, muscular dystrophy, multiple sclerosis, partial or completely missing limbs, mobility impairments requiring a wheelchair, major depressive disorder, bipolar, PTSD, obsessive compulsive disorder, and schizophrenia. And sometimes when you're dealing with someone with a mental health issue, they may not be aware that they have one. So you need to be aware that it is a possibility based on how your client is behaving with you, what they are accused of doing, the current issue that they have. They may not be aware of such. And so when Lizzie speaks, she's going to talk to you a little bit about elder issues, but it would also apply to anyone who's laboring under a disability. Sometimes they just may not know. And if they don't know, you may have to hear from a loved one or a friend or a paramour, as one of my favorite attorneys usually says. They may be able to tell you that this person has this issue. Okay, so be aware that you may not get it directly from the client. You just have to be aware of what's going on and the various symptoms. Now, on to the next slide, which is hoarding. Hoarding is always one of my favorite and least favorite topics. So Lizzie's smiling because she is aware that I have had at least one hoarding client, and it was quite an adventure. Okay. And I will tell you that hoarding is a recognized disability. And as such, you don't need a letter from a doctor saying she's disabled. If she's hoarding, she's disabled. If he's hoarding, he's disabled. Whoever's hoarding, they're disabled. It is a compulsive disorder. And it's basically acquiring excessive amount of items with no apparent value or no concern for value. And discarding items that others may consider to be trash feels like throwing away a piece of themselves. That's why it's so hard, because you will say, hey, you're about to lose your house, just clean up. Just throw it all out. Would you rather be on the street, right? That makes sense, right? It's either you or your stuff. That makes sense to us. But to them, they are throwing away a piece of themselves, and they can't do it. Also, they are ashamed of the condition. They may have justified it in their own brain. They are overwhelmed by the situation. It causes them anxiety to think about it, or they may have another, and typically do another diagnosis, which I shouldn't say diagnosis, condition, because they may have not been diagnosed. It can sometimes be a symptom of another mental health issue, depression, severe depression, and the items could also cause them anxiety. They could be schizophrenic. I had a client who was schizophrenic and hoarding as part of the schizophrenia. It will lead to indecisiveness and avoidance and shame and procrastination, and it just feeds the cycle of the hoarding, because the only thing that brings them comfort is to accumulate more stuff. And so they will either feel safe, or this type of thing has an emotional significance. One thing I hear a lot is, I will probably need it in the future. And they don't want to waste anything. So I will say, if you are going to, excuse me, if you're dealing with a hoarder, know that it is a disability. But also know that you are only going to be successful if this person who is hoarding also has the intervention of a social worker, a case manager, someone like that. Without that, whatever you do for them is ultimately, in my experience, not going to be successful, because it is a compulsive disorder that they can't help. And if no one is helping them with the disorder, they will keep doing it. They can try their best to get rid of the things, but because it is a disorder that they can't really control, they need help. And when you're dealing with a hoarder, what I like to do, especially if it's public housing, is you send a reasonable accommodation to clean up the stuff for more time to get the house and the apartment or house in order. But I also send it to the housing authority, because what happens is they will get the notice, and then they'll also have their voucher terminated. So you need to send your reasonable accommodation request to both the housing authority and the landlord. And that is kind of my standard practice if I'm dealing with a housing authority situation. Even if it's Section 8, I will send it to the landlord, and I will send it to the housing authority. Any questions before I move forward with after talking about hoarders?
Yes, Andrea, we did have one question come in. Can you give an example of a record of such impairment? Now, I'm not sure which disability she was referring to.
Oh, okay. So the definition of disability is sometimes you have a record or you're regarded as disabled. So I would say anybody who would know, if they would say that this person has this problem or has had this problem for a while, I think it all kind of falls within that. It's hard to, without a doctor, it's hard to document, but you would have someone who would know to state, she's had this over the years, or depending on the disability, possibly police reports or medical visits, but you want to be careful of that because you don't want to disclose too much information to a housing provider because they don't need it and it's not required. Any other questions?
That's it for now.
Okay. That was a classic attorney, it depends answer. So how do you establish disability for a reasonable accommodation? Well, it's kind of along what we were talking about. If the housing provider known or should have known, how can the housing provider know or should have known, does anyone think? So while you guys are trying to think whether you're going to answer, my presentation style in person is I go around and I call on people and I wait for them to answer. I think this webinar will be more fruitful to you if you participate as opposed to having me read these slides to you. So known or should have known. How would a housing provider know or should have known that a person is disabled? How do you think? What do you think?
All right, we have some responses coming in. The first one is the landlord has been asked in the past for a reasonable accommodation.
Mm-hmm.
Sometimes tenants tell the landlord thinking they can trust the landlord.
Mm-hmm.
And the last one is physical versus mental.
Oh, you mean if it's obvious?
I guess so. It's hard to tell on webinars. You can't make people elaborate.
Okay, possibly. Okay.
Another response was they may be receiving SSD or SSI.
Mm-hmm.
And another person said SSI also. They could have mentioned it in their rental application. Great responses, everyone. Thanks for participating.
Yeah, that is excellent, and you will have to all keep participating because I'll sit here and drink my coffee because I already know this stuff. That's what I always tell
We have
people.
a few more that just came in. The housing provider could look at the type of assistance they are receiving.
Right.
Sometimes tenants are working with a social service provider.
Mm-hmm. 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 Yes, all of those are correct and wonderful, and I'm so happy that you guys know these things because when you are sometimes dealing with the opposing side, they may say, well, we need a letter from a doctor that says they're disabled. And we all know that that is not the case, right? You can say that this person is obviously disabled, right? They're in a wheelchair, they walk with a cane, they have a limp. They have to certify every year, and you know that their income source is Social Security disability, or they volunteered that they are disabled. All those things mean that the housing provider should have known that this person is disabled. You can have a credible statement by an individual, a doctor or other medical professional, peer support group, a non-medical service agency, a reliable third party. Now, who's that? Well, hey, my big sister knows that since the day I was born, since I was 5, I have been, hearing voices or whatever the case may be. That is a credible third party. Who would be better to know than someone who has known me all my life? So please be aware there are other ways to establish disability. The particular rub comes in when you have to establish for certain requests like emotional support animals and that type of thing. Sometimes the guidance does require a medical letter, but you can establish disability many ways. Okay. Now, everyone knows that the housing provider can't ask for specifics on the disability. And the housing provider should only seek information that is necessary to evaluate whether an accommodation is necessary because of disability. What will happen though is that the clients will sign these releases, and the medical doctor will just send your entire medical file or send the last time you visited and asked for the note, they will say your diagnosis, they will say your weight, they'll give your whole medical history, and that's what you give to the housing provider, and that's too much. And when my clients come to me with that and they haven't handed it over yet, I say, no, this is not going to work. We need to do a different letter. You should not be disclosing your client's medical history, even if that's what they give you to disclose, because clients don't know better. Now, sometimes there are timing issues and things like that, but I would say do your very best not to disclose too many medical details. Next slide.
Andrea, before we move on, do you mind answering a question about senior complexes?
Well, we will have Lizzie speaking soon, so you might want to hold on to that.
I'll save.
Yeah, let's hold on to that, and we may be able to deal with that. But what's the question, so I have it in mind? Because I can't.
Okay, the question is, how do you establish disability and reasonable accommodation for common area repairs and distinguish your client as disabled, even though many other residents might be, and not get stuck in the landlord-tenant zone?
Common area repairs. That's fascinating. Okay, let's keep that in the back of our mind. All right, denials. When can a reasonable accommodation request be denied, group? This is one of those Fair Housing 101 questions. When can you be denied? Well, it's right there on the slide. If there is no disability or no disability related need, and it is not reasonable. Now, having done this for a while, I often get responses from private attorneys who don't know fair housing law, but they did a quick Google search in response to my RA, and they will say, this is not reasonable. And what they mean by that is we don't like it and we don't want to do it. But the law says that there's only a small criteria for whether my request is reasonable or not, and that is if my request is a fundamental alteration of the essential nature of the provider's operations, if it provides undue financial and administrative burden, if the person or animal is a clear and present danger to the health and safety of other tenants, and the actions have or will result in significant structural damage. Okay, so let's sit with that for a minute. What do you think? What do you think is a fundamental alteration of the essential nature of a provider's operations? What would that be? I mean, we all read it, we all look at it, but what is it? Well, if we're dealing with a housing provider, anything that would alter them from being a housing provider. So if it's not in relation to providing housing or a service that they already provide, it can be a fundamental alteration of the essential nature of the provider's operations. So for instance, if you're physically disabled and you can't make it to the bus stop and you want the maintenance person to come pick you up in his little cart that he picks up, you know, other things with around the park and drive you to the bus stop, that is a fundamental alteration of the essential nature of the provider's operations. They're in the business of housing, not transportation, right? So any questions about that right there, the fundamental alteration? We all have that. We all kind of have a idea, a concept of what that is. We feel comfortable knowing if something is a fundamental alteration.
We just had a comment come in that an agoraphobic person may ask people to go shopping for them because they cannot leave the house.
Right. Again, excellent. Yes, that is another example of a fundamental alteration. And I don't know about you, but because of this COVID, I'm hoping I don't get agoraphobic and decide I will not leave the house. But we'll see. I'm feeling kind of Are you guys feeling a little stressed because of COVID? It's okay if you are, because I am, and we can all be stressed together. But yes, undue financial and administrative burden. Ooh, what's an example of that? What's undue financial and administrative burden?
Installing an elevator in a building.
Mm-hmm. Installing a walkway from your house from your apartment to something that's, you know, half a football field away, because you don't want to go on because you can't go on the grass. Different things like
Good one. I want granite installed on my floor because I'm allergic to carpets.
Yes. Oh gosh, I will not tell you that story, but I have a story on that. I will not share it. Well, thank you for bringing it up. I think I know who did, but thank you very much. Yes, that is a prime example of undue financial burden, in that you need an accommodation, but you want a particular, you want it solved in a particular way that's going to be very costly for the housing provider. Granite floor, marble, if people do marble floors, I don't know, but you know, something like that is very costly, and the housing provider does not have to do that. But the note says even if it is unreasonable, they have to participate in what's called the interactive process. And I will sometimes use that term when I'm trying to reach out to a housing provider, and I know that what I'm doing is a close call, or my client doesn't always have what they need to establish everything they need to establish. I will go, let's try and start the interactive process. And what's the interactive process? Where if they say this is unreasonable, and we can do, instead of granite floors, we can do, what are floors made of? Wood. We can do wood. Then you can go back and forth about what would be a suitable alternative to what you're requesting, if what you're requesting is undue financial or administrative burden, or changes the essential nature of the provider's operations. For instance, if you need them to lay down a cement walkway that's half a football field away, another option would be, how about we just relocate you to a unit that is closer to where you're trying to get to, or closer to the ramp that's already there. That's an option. So with animals, sometimes they will say that, you know, they can't have this animal because it's a dangerous breed, and the HUD has been clear that you can't make any breed related restrictions on service animals or on emotional support animals. So you can't deny an animal because of its breed, or any theories about, okay, this is a dangerous breed. It has to be based on the actions of the individual animal. So as a person with way too many dogs, I have a Chihuahua and I have a Pit Bull. And I will tell you that you are more likely to get bit by my Chihuahua, because they are mean little things, and they will bite. So if you have a emotional support animal and that animal bites someone, what happens with your emotional support animal? Anyone?
I
What
don't think
happens?
anyone wants to speculate. Here we go. Here we go. The animal can be removed because it has the propensity to bite. The reasonable accommodation can be denied.
Yep.
It could be destroyed, removed
Oh,
from premises.
who's gonna destroy your emotional support animal?
Animal control, maybe. There is sort of a question mixed in here. What if the insurance has a provision that if you allow the restricted breed, they will not cover?
Excellent. So if if the housing provider says the insurance will not cover that breed, if the housing provider says local zoning ordinances will not cover that breed, they need to apply for an accommodation. They need to inform their insurance company that they have an accommodation request, and by federal law, they have to honor it. And they need to apply for an exemption to the zoning regulations to the zoning boards. So they have to take a step to try and comply with the law. They can't just say, I can't do it. And
Okay.
remember this is federal law, not state law. And supremacy clause. I can't say it this morning, but you know what it is. Supremacy clause. I always remember that. Also, if you have someone who is schizophrenic and runs out in the middle of the street naked, screaming at people, or gets into a fight with a neighbor, okay, they may want to argue that this person is a clear and present danger. Now, depending on the circumstances, you can get around that. And let me tell you how. If the person does not use a weapon during this altercation, then part of what you're going to have to do is a little bit of what I like to call lawyer social work. You're going to have to make sure that they are on medication, that they are seeing a medical provider, and that they will, have, check-ins and can report that they are complying with their medication schedule. That is a way to kind of counter the argument that they are a danger. Now, if they use a weapon or severely hurt someone, I think you're out of luck no matter what. But in situations where there was just a fight or screaming back and forth and maybe property damage, that type of thing, you can still work with that. So just be aware, but it's going to require, like I said, a little bit of social work on your part. So just be prepared for that. Know about agencies that can help people comply, because many places have caseworkers, and you just need to know what to ask the client for, because a lot of these mental health conditions, if you don't ask the exact right word, then you never ask them. I've had that come up quite a few times. And I've said, you know what I was getting at, and they were like, no, you never asked me, so I never told you. That is a common thing that happens to me quite often, so be aware of that. Actions that will result in significant structural change. Well, the easiest one is a hoarder, right? If they have too many things, they could destroy the floor. They could invite pests. They are a fire hazard, all these things. So if their hoarding has gotten to an extent that the floor underneath is damaged or gone, or that type of thing, they don't have to continue to do that, because that's a danger. Any questions about denials before I move forward?
We have a couple questions. Let me go back and see if they're about denials.
All right.
Okay, so the first one is the third party who is not a professional is argued a lot in court.
Yes.
I have read a case where a judge, no matter how much knowledge the third party has of the person's disability, has dismissed the case because a professional was not involved and there was no professional diagnosis.
Yes. I do not disagree. And I think that next week, Marty will tell you that you do not go to court without a medical doctor letter. And I don't disagree with that. But not all cases will go to court, right? So as many cases, as many reasonable accommodations as I've had, and I've had a lot of them, not all of them are suitable for court. So sometimes you have to deal with the hand that you're dealt, right? So if you don't have that, then your best route might be a 903 instead of going to court. So just be aware of that. But I agree with you, and I think Marty, who's presenting next week, will absolutely agree with you if that wasn't Marty himself. Yes, you can't. You shouldn't. He's said this to me. You have to have a doctor's letter if you're going to go to court. And listen, it's unfortunate, but it's true. This is HUD guidance. It's not law, right? It's not a statute. So if you're going based on the HUD guidance, then, and it's not a strong court, it wouldn't also stand up in court, then you need to pursue the 903 route as opposed to the court route.
Okay, and we had one more question. How about when you have a client who is hoarding things and the complex is claiming your client's messy, cluttered apartment puts other tenants at risk?
Right, it does. But you're going to ask for accommodation to allow him or her to correct that. That's the point of the accommodation. Hoarding is a disability. So it's a disability. So you send the reasonable accommodation request, and what you're asking for is more time to come into compliance, right? Because ultimately that's the goal. That's all they want. They want your client to come into compliance. And so usually it's a 7-day notice, and no hoarder or anyone with a lot of stuff can get that out in 7 days. Okay. So what you're asking for is more time to come into compliance. That request is going to, again, work better if they are working with a mental health professional, because you can say, listen, this person is now in treatment and we have community organizations that's willing to help them, and understand the cleaning out process is just as traumatic as anything else, right? Because you can't just go in with a bulldozer and grab the stuff and pull it out and have it cleaned. That's not how it works. These are people's possessions that may appear worthless to you or I, but it's very meaningful to them. So you can't just go in. I mean, we've all watched hoarders. You're like, why is this so hard for you? But it's because it's a mental illness. And so they need time. Now, you're not going to get indefinite time, but they do need time. And so it becomes an easier process if they're working with someone to get it done. And I will tell you that most hoarders I've come across are very intelligent individuals. And when I say very intelligent, I mean it. They are very smart, but they have a really hard time dealing with the possessions, the number of it, the people's reactions to it. So it's a whole complicated scenario. So you're going to ask for more time to comply. And they have to, by law, give it to you. So you send the reasonable accommodation request to the landlord, and you send it to the housing provider. And then you do your best to ensure that your client is receiving mental health services. Okay, so I'm going to speed up a little bit because I look like we're running out of time already. They can't deny you if you don't use magic language like I need a reasonable accommodation request, right? They could say, listen, I lost my leg, I need this. They could just say it. They don't have to say reasonable accommodation request. It could be oral. It does not have to be in writing. It does not require a particular form. Be aware of this. A lot of housing providers will take no action unless your client fills out a form. That is against the law. If they make the request, they have to respond. The form is not required. And so if your client just made a verbal request and they took no response because the form wasn't filled out, then they violated the law. There are no fees or extra deposits, or insurance. A lot of times, if you're dealing with a breed that they're uncomfortable with, they want you to get insurance, extra insurance. That is not necessary, and you can say no to that. No extra deposits, you can say no, none of that, no fees associated with a reasonable accommodation request. Next slide, Christy. What is a reasonable modification? So a modification is a structural change to existing premises. Grab bars, lift bars in the bathroom, removing carpet due to allergies, lowering cabinets because you are now in a wheelchair, installing light indication for doorbells. That's a modification. There is a HUD statement on modifications, as you can see. There is a HUD statement on just about everything. But there you are. And what's funny is I didn't know this existed until I found it yesterday. So there are additional reasonable modification considerations. Unless you, next slide, Christy. Next slide. Unless you have too far. Unless you have a subsidy. You're going too far, Christy. Christy's going ahead. We're running out of time. Christy wants me to hurry up.
The computer is doing it by itself. Just a second. Sorry, guys.
Christy said, get this show on the road. So unless you have a subsidy or your housing provider receives some kind of federal assistance, the client is required to pay for the modifications and may be required to return the house to original condition. They have to have prior approval before they do a modification. And the housing provider, HP is a housing provider, can require a permit and that the work be performed in a workmanlike manner, and can require a more aesthetically pleasing alteration if there's no additional cost to the tenant. So let me address this just a bit. So clients are often surprised that they have to pay for a modification. When it comes, you have to know the difference between what you're asking for. Now, if you are dealing with subsidized or public housing, there is no difference. It doesn't make a difference. Everything's a reasonable accommodation, even a modification, right? So if you're dealing with public housing or something like that, it's all reasonable accommodation. It doesn't matter, and they pay. But if you're dealing with a different kind of housing provider, then you have to be clear what you're asking for. It's a reasonable modification. And I have seen cases, and I haven't had a chance to delve into this deeper, where if you're asking for a reasonable modification and your housing provider does not have to pay, then you have to say that you're going to do this at your own expense in your modification request. Modifications have to be done at the tenant's or requester's expense. So sometimes we're dealing with something as simple as grab bars, and your client has zero income, and their income is, they don't have enough to have grab bars done. Now, I've seen it both ways, where landlords are not required, but because they want it to look a certain way, they'll install it. They'll just install it. And then I've seen others who are just horrible, and they'll just go, no, we're not gonna pay for it. They can pay for it themselves, which they can do. But just be aware of that when your client is asking for a modification. When you speak to them, when you're talking to them, let them know if indeed they have to pay for it. Work performed in a workmanlike manner. Can the housing provider require a particular contractor? What do you think? And when I drink my coffee, that means I'm waiting for you to answer.
We got a no and a yes.
Okay. So the housing provider cannot require a particular contractor. They cannot require that you work with their favorite contractor. They can't do that. Is restoration required? For the sake of time, I'm going to answer this question. Yes and no. Like all good legal questions, it depends, right? So if the person coming after you can make some benefit of this, or the landlord can have benefit of it, usually you will not have to restore it. But if it is just something that is particular to you and will be of use to you and no one else, then yes, you have to restore it when you leave. All right. So we have to move a little forward because we're going late. Now we're going to deal with older Americans. What is the problem with old folks, Lizzie? The problem with old folks is age is not a protected class. However, they will usually fall into another protected class, and that's disability. We all kind of age the same, and things stop working on you as you get older. This is just part of life. So you can kind of get around the age not being a protected class issue, usually with disability. And then as a note, registered 55 plus and 65 plus communities have what's called familial status exemption, right? But they have to comply with the remainder of the Fair Housing Act. And I've had to send reasonable accommodation letters that say, while you are exempt from familial status, you must honor the rest of the protected classes, because they need a reminder every once in a while. Sometimes they think they're exempt from the entire thing, and they are not. It is clear. So please remember that. And then usually it's only a certain percentage of people have to be this age, that type of thing. So there can be ways around it, but just be aware. That's the issue with older Americans. But with COVID coming around, a lot of things that you can do for your older clients would also apply to our current clients. I have a friend who has a client who is now in a coma. What do you do? Because of COVID, what do you do? What happens when your client is not capable of helping you and going forward, and you're litigating a case, you're in the middle of a case? What do you do? These issues can come up not just for elders, but for everyone, especially our population of clients, because our population of clients are at risk because they already have pre-existing issues. So Lizzie is my special guest. Lizzie works here, and she is our senior attorney of the older adult, manager of the attorney of older adult programs at CLSMF. She also reminds me not to say old people, but I do it anyway. And she's going to go over a couple things very quickly that I think will be helpful to all of us, not just in aging, but with all our clients with COVID-19. So thank you for popping in, Lizzie, and she will have a more extensive presentation next week. So please join us then. But Lizzie?
Yes, a couple of things. First, you mentioned that you can ask for a reasonable accommodation if the person is disabled, but there's also something to remember that 26.5% of Floridians, and there's over 20 million people who reside in Florida, 26.5% are over the age of 60. In 2016, the AARP reported that over 161,000 grandparents were raising their grandchildren. So that may also be grounds for a potential reasonable accommodation for familiar status, especially if some of the noise complaints, unauthorized guests, or maybe the person who needs the pet, maybe the grandchild, the minor grandchild that's now residing with the grandparent. As far as some of the elder issues that's going to rise due to possibly COVID or just the nature of someone being disabled will be diminished capacity. And there's a difference between the diminished capacity and guardianship. The guardianship goes more to incompetency and diminished capacity. Diminished capacity over the last, I believe, 5 years or so has been a major issue that the Florida Bar has been addressing in many, many, many CLEs across the state, because it is an increasing issue when we're litigating. It probably has always been there, but this is now something that has becoming more of a problem, and we have a lot of ethical issues, which I'm not going to address today. So when it comes to diminished capacity, when I see a client with diminished capacity, or if I have a coworker and we're talking, consulting on how we can best address the needs of that particular client holistically, I always ask them, have you read Florida Rules of Civil Procedure 1.260B? 1.260B goes to a suggestion of incapacity. It follows the same procedure of a suggestion of death. And basically you're saying, hey, Your Honor, this person cannot effectively participate in their case. They cannot effectively assist me in defending their action. And so therefore they cannot appreciate the consequences of this legal action. And we need basically like an attorney ad litem, which really is in debate of whether that's appropriate method in some of our cases. But in this particular case, we need someone who can represent the interests of this particular litigant because they cannot assist themselves. So you can file a suggestion of incapacity, and you can request a hearing under the Florida Rules of Civil Procedure. How that's going to work out is it all depends on the type of case. I find that if you're in a foreclosure, I learned a couple of years ago that some foreclosure mills have a little kitty, and I say kitty fund. So often they will pay for that attorney ad litem / guardian ad litem to be appointed to represent the interests of the litigant and to move the case along. As far as paying for a guardianship, usually almost always it's a flat out, I'm not paying for that, because guardianships are typically $3,000 to $5,000 is timely, and they're just not going to pay for it. And I haven't seen judges who's going to make them pay for it. Another thing with diminished capacity is you have ethical.
Lizzie, can I just chime in there?
Yes.
With the suggestion of incapacity? I've found that when I filed one in my eviction case, believe it or not, with a disabled client, the court, no one knew what to do. So it just ended up resolving itself. But don't let the cost or the fact that no one's going to pay for it keep you from doing it, because you have an obligation. Your bar card is your obligation to do so.
Yes.
So please remember that you have to file that, even if you don't know what to do after. You have to put the court on notice, because that's your obligation as an attorney. I'm sorry, go ahead.
No, and that's a good point. That I know in my first case, no one really did it in office, so I had to figure it out on my own. But I found that Ballard versus Wood, which is a 50 CA that's been around since 2004, is still in effect, and it gives the court a lot of guidance. I believe it was some kind of foreclosure or something like that kind of case. It was a real estate case, and the judge and I believe the appellate court referenced that just by the judge being aware of the incapacity, even if the lawyer didn't know what the process was, basically put the case in jeopardy if the judge goes ahead and issues a judgment like they did in that particular case without addressing the incapacity of that particular litigant. So the fifth,
reversible.
yes, so it was reversed and it was sent back on remand for rehearing. So they had to address that. Okay. Another thing I find is that you got caregivers. So you have third parties, and the Florida Bar has all kind of ethical rules about third parties. We have best practices about third parties. So when do you talk to the third party? When can a lawyer talk to the third party? Every lawyer is different. I first pull my client into the room to talk to my client to determine what my client know and don't know. How can they help me? Can they help me? Can they give me the information? Do they need this third party? Who is this third party? Is the third party just someone who's driving them to the office to drop them off? Is the third party a relative who's overly involved and into the case it's not necessary? How much information do I need from the third party? Because even if I talk to the third party, I still have an ethical obligation to limit my disclosure and my actions with them to as much as needed to effectively assist my client. So I do in some cases and I don't in some cases. Just like we have people call in and say they have a POA, and just because you're a power of attorney, do I need you? My client is totally competent. And on top of that, you're calling me, my client is calling me for a will. Why would I take my directions from you with the power of attorney to draft a will or something else that's as significant when I need the client? And because I'm always concerned about exploitation.
I was going to mention that, Lizzie. It can go both ways. I've had it where a third party will kind of illuminate the situation for you because the client can't even tell you the extent of their issues. And then we've also had it where the other person, like you said, is a negative influence on the situation and putting pressure on them, especially with the elderly clients. You may have an older child who is physically imposing, or someone who's manipulating them. So you have to be aware that you have to kind of separate them and talk to them separate, and be aware if someone doesn't want you to talk to this other person first by themselves, because that's a sign.
Yes. And lastly, I briefly talk about access to premises. Andrea mentioned about what should we do about a client who's in COVID. Well, if they have COVID, that creates extra issues also. Like that particular person more than likely is going to need a guardianship, whether it's temporary for 90 days as an emergency guardianship, or whether it's limited plenary. That's something, it all depends, because we don't really know the long-term effects of what's going to happen from those who have been diagnosed with COVID. Another issue is access to premises. In the meantime, how do we get their stuff or their belongings? And it's a simple little piece of paper, like an addendum to a contract, where someone can, while they're cognizant, of course, can simply go ahead and pre-nominate someone to be responsible to gather and take possession of their personal belongings in the event of an incapacity or death. And I think that's all the time I have.
Oh, thank you, Lizzie. Yes, that notice is very helpful, and I think we should be suggesting it to our clients, especially in the age of COVID, who can enter your apartment should something happen to you. That's an important thing. So even though it's helpful for our elder clients, think of these things and start they could be suggested and they can have it as advanced planning. With COVID going on, we have to consider this for all our clients, and we may try and bring it up to all our clients. Have you considered, especially if they're sick? A lot of our clients are sick. They have existing conditions that make them more susceptible. So it's a real concern. Who can get in and who can access my apartment? Who's going to take care of my animal? Right? These are all things we need to consider in the age of COVID, because you can be fine one day and the next day not. Okay, so Christy, I am going over my time. Would we like me to finish and then we could take a shorter break and keep going? Would that be okay with everyone?
Sure, I think 5 minutes will give everyone time to stretch.
5 minutes? I'm an attorney, I can talk forever. Okay. Let's go to the next slide and then the next slide.
Okay.
All right, pets, service animals, emotional support animals. These are the ones that everybody loves. All right, so next slide. Those are the HUD opinions that I am aware of in regards to, and the ADA guidelines in regards to service animals and emotional support animals. There was a guide in 2013 and a new one came out this year. Next slide. What is a pet? Anyone? What's a pet? Well, I'll tell you. A pet is an animal or usually domesticated, kept for the pleasure rather than utility. And it is not a service animal or emotional support animal. Okay, next slide. Service animal, an animal that is trained to assist a disabled person with one or more aspects of their disability. So I got a couple true or falses. So we only got a little bit of time, so you guys got to participate quick. True or false? Any animal can be a service animal. True or false? False. A service animal in training is a service animal. Anyone? True or false? You could just write T or F. True or false?
Got a couple falses and one true.
For a service animal in training as a service animal, that is false. A service animal in training is an emotional support animal. It's only a service animal when it is trained to assist with one or more aspects of the disability. So if it's not trained yet, it is not a service animal. Next, a service animal must be professionally trained. True or false? What do you think?
False. Got a lot of false.
Yes, it is false. You guys are good. The handler can be the person who trains the animal. So then that leads us to the last one. A service animal must be certified. True or false?
Got a couple trues and a couple falses, about evenly split.
Okay, you guys are excellent. I love you guys. A service animal must be certified. That is false. That is a preconceived notion that a lot of people have. There is no service animal certification. Next slide. When you are dealing with a service animal, there is only two permissible inquiries. Is this dog a service animal? And what work has the dog been trained to perform? By the way, there are only technically two service animals, a dog and a miniature horse. No other animal is a service animal. That means, Lizzie, no monkey. That's an inside joke between me and Lizzie. And so that's the only inquiry that can be made in regards to a service animal. And even then, you can't make that inquiry if it's obvious what the service animal is doing. So if it's a person with a service animal next to them, you can't even make an inquiry. So the vest isn't required, the ID isn't required, none of that is required. But they do it to reduce the likelihood that they will be questioned, right? But the service animal must always be under the person's control, and that is not necessarily a leash. Sometimes an animal is trained to go in advance. For someone who was in the military and they have PTSD, their dog goes in, makes sure the room is clear, and then comes back. Can't happen on a leash. So be aware, a leash is not always required. And so if one of your agreements with your providers is the animal must always be leashed, be aware that does not always have to be the case. And if an entity has to comply with ADA and the Fair Housing Act, they have to do both. So they have to start with, is this animal a service animal? And if it is, the inquiry stops. And if it isn't, then they move on to the emotional support animal inquiry. So please be aware of that. Next page. Emotional support animals. They provide emotional support and comfort that alleviates one or more identified effects of a person's disability. Ooh, I needed a space in there. True or false? A housing provider can ask for documentation of disability-related need for emotional support animal from a healthcare professional. True or false? You guys gotta be quick because we're running out of time.
Between true and false.
It is true. Per the HUD guidelines, it should be a healthcare professional. And it's emotional support animal. True or false, housing provider can require a tenant to complete an accommodation form and allow contact with a doctor to verify disability. And doctor is not from an online scam.
Everyone says false.
You guys got it. It's false. If your letter says what it needs to say, they don't ever need to fill out a form. They don't ever need to be contacted. The doctor never needs to be contacted. The letter from the doctor should vouch for the animal under the new guidelines. True or false?
False.
Yes, always false. And the last one, any animal could be emotional support animal. True or false?
We're kind of evenly split between true and false.
Well, some of you have read the new guidelines, but it is still true. Any animal could be an emotional support animal. It's just going to be harder for some than others. All right, next page. On the next slide, these are the animals commonly kept in households. This is per the new HUD guidance. All right. Next slide. These are unique animals. All right. So I used to give this presentation and say, Craig, the gator, could be my emotional support animal. And tell me why I can't have them, right? That is technically off now, right? So we have Craig, we have Shirley, we have Brian, right? I love animals. These are my animals. How can I get them to be my emotional support animal, right? This is what I need. The doctor says I need it. So how do I get it to happen? Well, under the new HUD guidance, you have as the requester, a substantial burden of demonstrating a disability-related and therapeutic need for this specific animal or this specific type of animal. So again, going to the monkey, which makes me and Lizzie laugh, is because we had an emotional support animal case or our servicing, I can't remember, and it was a monkey. And monkeys have their own issues because they have to come through another department. They're regulated. It's just a mess. So if somebody has an emotional support monkey, run. Don't just run. Stay away from the monkeys. It's real complicated with monkeys. Shirley. Now, how can I have Shirley as my emotional support animal? Well, when you're dealing with an autistic child, they sometimes have a response to chickens for some reason. I'm not sure why. Or so you have to provide them with a coop and that type of thing. But there is a possibility that you can have a doctor say that you need Shirley as an emotional support animal as opposed to a dog. But I think under the new guidelines, you're gonna have a real hard time getting Craig now. So I gotta give Craig to a sanctuary. Okay. Next slide. And oh good, we're almost done. Drafting your reasonable accommodation request. Okay, kids, this is the important part. I have a sample reasonable accommodation request in the document, so don't worry. You have to ID the requester, give the address, state whether it is mental or physical disability. You need to state that the housing provider is subject to the Fair Housing Act. Give some Fair Housing Act language. State the situation that has prompted the letter. For instance, my client received a 7-day notice in regards to an unauthorized animal. My client has had this animal for years and it is their emotional support animal and that type of thing. And then you need to state clearly what is being requested. You have to be specific. You can't just say reasonable accommodation request. You have to be specific as to what you want, because if they don't do something that you didn't request, they haven't done anything wrong. So know and get to know in advance what type of things should be in your request, and then give them a deadline to get back to you and how to do so. And the new guidelines say 10 days by email, by letter, and attach a healthcare provider letter if needed, right? So when would you not need a doctor's note? Well, if your client needs an assigned parking space and they're in a wheelchair, that does not require a doctor's note, right? It's an obvious disability and an obvious need. They just need an assigned parking space. And sometimes they will come back and say, well, there's plenty of parking. No, it doesn't matter. Your client is entitled to an assigned disabled parking spot, always. Please remember that. Healthcare provider letter. So what is this? Every time I do a reasonable accommodation request, 9 times out of 10, the doctor's letter is wrong, right? It's wrong. It either gives too much or not enough. It's wrong. And so the language will come back and it will say, please allow, my client would prefer, let them have their pet. All kind of language that is not helpful, right? So the healthcare provider's letter should say that this is what the accommodation request is. If it is an emotional support letter, it's best to identify the animal. It's my client's Chihuahua Pikachu. My client's 7-pound Chihuahua Pikachu as her emotional support animal, and she's requesting an exemption from her provider. And to qualify for that exemption, she must be disabled pursuant to the Fair Housing Act, and I give the Fair Housing Act language. And as a result of her disability, the animal is need, not preferred, not wanted, not liked, needed to alleviate one or more symptoms, or alleviate or mitigate one or more symptoms of the disability. And in my letter, which I stole from Marty, the lawyer, and tweaked a little bit, and he's presenting next week, I say, listen, if you agree with the above, you can put it in a letter on your own letterhead, or for your convenience, you could just sign and send it back. Let me tell you, every time I send out that letter, I get it signed, I get it sent back, and there's no issues. Doctors don't want to think too much about this. And I've come to the place where you just have to give them the letter. Don't send the client off and say, this is what I need. Tell your doctor this is what you need. It will never happen. It will just waste time. Do the letter, have them sign a HIPAA request, and send it off, and you will get it back. Because if your doctor agrees, they'll just sign and send it back. If they don't, they won't. But that is the best thing that you can do. If you take, Marty did this when we were rehearsing. If you remember one thing from this presentation, draft your own doctor's letter. And there's a sample in your handouts that I drafted for you. And I hope that you will find it helpful. So do we have any questions? I'm running over time, and I so apologize to my fellow presenters.
I wanted to make sure we went back to the question about how to prove disability and the need for reasonable accommodation in senior complexes.
Right.
If you answer that.
What was the question? I don't remember.
I'm going back. That's the gist of what I remember.
Well, if you're in a senior complex, you can prove disability if there is a disability, right? So if this person is disabled or regarded as disabled, or any of those things, then they're disabled. Just because it's a senior complex doesn't mean they don't have to comply with the Fair Housing Act.
Exactly. And if it's something new, like a new illness, like whether they have dementia or something like that, you can always get a doctor's letter to support that they have a new disability, even though they're not getting Social Security disability necessarily.
Okay, that makes sense. One more, can you explain the circumstances when the landlord ignores the request for a reasonable accommodation? What alternatives does a person have to get the reasonable accommodation?
Well, I'm glad you asked. One of the things you can do is file a 903 complaint, which we're going to discuss next. So you are in the right place. Another thing you can do is file a federal lawsuit, which we are going to be discussing next week. So those are your two options. They must comply, or you file a housing complaint or a 903 complaint. But all of this starts with your reasonable accommodation request, which is why I started with this presentation. You have to have a proper RA, and if you don't, they haven't done anything wrong. So it starts with you. Your request must be what it needs to be to trigger their responsibility. So this is how it starts. You start with a good reasonable accommodation request, and then you move on should they fail to comply.
Okay, we got some clarification about the senior complex question. The questioner wanted to know how you get a reasonable accommodation for repairs to common areas without getting stuck in the landlord-tenant zone, i.e. the landlord or HUD argues it's not a reasonable accommodation.
I think for that one, I probably need to know more. So on the next slide, you will see my email, and you can just email it to me and we'll talk about it.
And we have a question about service animals or emotional support animals. If someone has a monkey or another unique animal as an ESA, can they be allowed to take the animal into a public place like a grocery store?
Okay, emotional support animal is not a service animal, and it is for your home. That's why it falls under the Department of Housing and Urban Development. It is for your home and your home only.
Okay, we got one more. If a person has requested a handicap parking space, do they get the right to have the space marked just for them? Or how are they protected as the only person using that parking spot?
Yes, you need to request an assigned parking space. So in your reasonable accommodation request, you don't just request a parking spot. You request an assigned parking spot. That's how you ensure that they are the only person using it. And yes, they are entitled to an assigned parking spot because God forbid they come home and someone's in the spot and they can't get out. And they need to get into their car or they need to get out of their car pretty promptly. So yes, you need to request in your accommodation, request a assigned parking spot, and then you need to know whether you need 2 parking spaces or 1 if the space isn't there, right? So if the client needs a wheelchair, has a wheelchair and needs room to get out, and there's no existing space where you want the spot, then you're going to be taking up 2 spaces. If the client just needs an assigned space, so there's no issue with parking, then that's something different. So you need to know what your client needs. That involves talking to your client and getting that information.
All right, thank you for all that good information. We got some compliments coming in too about thanking you for all the good information. Welcome back, everyone. I am happy to welcome Katherine Hanson, who is a senior staff attorney at Disability Rights Florida. And in the interest of time, we'll save questions for the end of her presentation.
Okay, so today I'm going to talk about some things that you might want to think through during the advocacy process if you're filing an administrative complaint or thinking about going to court. There are a couple typos in there, some mine, some not, so please forgive those. But before I start, I want everyone to remember that you're welcome and encouraged to please call me or email me if you have any fair housing questions or if you want to co-counsel on a case. I will repay the favor by asking to possibly send you a case. We at Disability Rights Florida are a statewide organization. I do only housing law involving people with disabilities. So I really need a network of legal aid and other attorneys throughout the state so that we can effectively help as many people as possible. So please feel free to call or email me and talk about fair housing stuff. Next slide. So first, there are some materials that you want to make sure you have at hand when you're really working on any fair housing case. The one at the top is the Complaint Intake, Investigation, and Conciliation Handbook, which you can find online. It's not super user-friendly in that you have to download a number of separate PDFs, but this is the rule book that HUD is supposed to follow when it's doing an investigation of an administrative complaint. So if you want to know what the rules of the road are, that's where you can look. And like I said, that's available online. There's also a memorandum from HUD called Reasonable Cause under the Fair Housing Act. It's pretty old at this point, but it has good information in it, which we'll talk about in a little bit. If you have the financial ability to get what I call the Red Book or Schwemm's Housing Discrimination Law and Litigation book, you should get it. You can use it online. It's a great resource. It has the answer to pretty much every question you are going to ask, and the online version is pretty user-friendly. As far as valuing complaints and damages, which we'll talk about, you want to definitely be familiar with the HUD and Department of Justice's recent accomplishments website, where you can find recent settlements, complaints, conciliations, that type of thing. And then Brad Pitt over there is telling us about the fair housing list. It is a closed list, so if you want to be on a listserv that is all fair housing all the time, then you should speak to somebody who does fair housing and see whether or not you can get an invitation. I'd really recommend, if you do fair housing work, to get on that list. It's a great way to reach fair housing lawyers from across the country, post your questions, help other people, share cases, all of those things. So one of the things that's in the Red Book, the Schwemm book, that you really might find useful, there are damages worksheets to help you value your cases. There's charts of settlements and awards. There's obviously the law. One thing that's not on my slide, which really should be, is your client. Know thy client is really important as far as knowing what to do when you're litigating a fair housing claim, because a lot of fair housing claims are about the impact on your client, their emotional distress, how they reacted to discrimination. So it's really important to know your client. Also not on the list is a law firm called Brancard and Brancard. which is out of California. They also have great materials that they're happy to share. They have all sorts of really great worksheets and spreadsheets to help you value your case. And they also have intake spreadsheets which are very useful to make sure that you have collected all the materials that you need. So we're going to talk about administrative complaints, and we can go to the next slide. I think it's important to remember that you don't have to choose between an administrative complaint and a complaint in state or federal court, yet anyway. You can file both an administrative complaint with HUD or a substantially equivalent agency and go to court at the same time. You can do that until basically the trial has commenced or you are starting the hearing process before the ALJ. And if you want to read the statute, you can look at 3612F, which tells you about the effective trial on administrative proceedings. And you'll see that the ALJ may not continue an administrative proceeding after the beginning of a trial in a civil action. So there are some reasons that you may want to do both at the same time. You can go to the next slide. So depending on your client, you may want to file an administrative complaint and a federal lawsuit, or what is more common is to file an administrative complaint while you're preparing to go to federal court or to get more information to support a federal lawsuit. So why would you want to do both, or why would you want to start with the administrative process? Well, the administrative process offers all sorts of benefits, including tolling, which means that your statute of limitations is not running during the time that your complaint is pending with the administrative agency. You get free discovery. You know, your investigator, your HUD investigator, or whoever is investigating for your local agency can get documents, they can talk to witnesses, they can interview people. Administrative complaints are a great way to avoid more protracted, expensive litigation. You can learn about weaknesses in your case, which is very important. Administrative complaints are really easy to file. And I think Mr. Barakal was talking about me when he talked about lengthy administrative complaints. And you also get free monitoring, which is really great, right? When you settle a case through HUD, HUD will make sure that the respondent follows the law for some period of time after the complaint is closed, which is not usually something that you as an advocate can do. So there are lots of benefits to going through the administrative process. And so it's important to take advantage of that, I think, if you can. Next slide. So after you file your administrative complaint, you'll be assigned to an investigator. So the investigator is a neutral party. Their job is to gather information from credible sources and figure out whether or not there's cause to believe that the Fair Housing Act has been violated. And that quotation comes from that handbook that I was telling you about that you can get online, which is HUD's investigation handbook. There are some things that the investigator is not supposed to do. They're not supposed to contact your client without your consent. This is a pet peeve of mine. I have heard of attorneys who will permit their client to be interviewed by the investigator without their presence. I would strongly counsel against that, against letting your client really talk to anybody involved in the case without you being there. So if they're interviewing your client, you have the right to be there, whether it's by conference call or whatever else, to make sure you know what was said, and so you can advocate for your client if needed. So at the close of the case, whether there's a cause determination or not, there will be a final investigative file. Always, always, always request the final investigative file. You don't know what kind of great stuff might be in there. I recently had a case that was a straightforward emotional support animal case, but when I got the investigative file, respondent had gone to all the trouble to write down all sorts of discriminatory statements in their materials from their condo board meeting. How great is that to have if you're thinking about going to federal court or if you're trying to settle the case, which is what happened in that circumstance. So always request that final investigative report and make sure you get the entire report, not just the cause determination. When you're working with your investigator, you want to be obviously professional, be helpful to the investigator. They have a lot of cases, they have to deal with a lot of lawyers, a lot of pro se people. If they need information from you or have a question for you, do what you can to respond in a timely fashion. Give them as much information as you can. And remember, as an attorney, it's always an opportunity to advocate for your client. So if it's obvious from the questions from the investigator that they have some concern about whether or not the law applies to your client, that's an opportunity to provide your assessment of what the law says. Okay, I think that's it for that one. So you can go to the next slide. So in addition to possibly trying to settle your case, one of your goals in the administrative process is to get a cause finding. So after HUD investigates or your local agency investigates, they will determine whether or not there's reasonable cause to believe that the Fair Housing Act has been violated. But the Fair Housing Act doesn't define reasonable cause, right? So what the reasonable cause memorandum tells us is that reasonable cause is essentially something between mere suspicion and a preponderance of the evidence. You have to establish, or the facts have to establish that there's a reasonable probability that a violation of the law occurred. So essentially, the investigator will be analyzing your facts in light of the law to see whether it's that a violation may have occurred. Next slide. There's a typo in this one. So I think this is some key language from the reasonable cause memo that I come back to over and over again. And I think one of the things that I've used on more than one occasion is if there's conflicting but reasonably believed evidence, the evidence may be construed in favor of the complainant. So sometimes there's not documentary evidence about whether or not something happened. Sometimes it's just people's testimony, right? And if that testimony is credible, it can be believed. The memo also explains that reasonable cause is present when facts exist to support a valid theory that the act was violated, so that a reasonable person could conclude that there was a violation. So you just want to make sure that you really understand that standard. It's not a federal court standard, so you know what is needed to get a determination of a reasonable cause, and you can ensure that that is what happens during the investigation. In the HUD process, there's no formal appeal, but you can request reconsideration. There's not like a formal form or anything like that, but you can write to HUD if you disagree with their finding and explain what error you believe that they have made. Next slide. So what can you get out of this process? What can your client get? Well, the relief available in the administrative process and in court is different, obviously. In the administrative process, you can get damages, which includes emotional distress. I have highlighted that for a reason, which we'll talk about in a bit, hopefully, if we have time. You can get permanent injunctive relief, equitable relief. So that would mean I want my emotional support animal approved. I want to be able to rent this apartment. You can get attorney's fees, and you can get a civil penalty, which we'll talk about in a moment. In state or federal court, you can get some of those same things, but you can also get punitive damages, which we'll also talk about. So just keep in mind that the relief that you can get, the things that your client can get, do differ depending on what forum you're in. So you need to keep that in mind. And before we leave this slide, I will tell you something that I'm sure you've been told before. Make sure when you're working on these cases that you're keeping good contemporaneous time records. That will be important, especially if you end up in court. Next slide. When you're wondering what the civil penalty may be, which can be useful for negotiating purposes, you want to make sure you check the most recent civil penalty. So the maximum civil penalty will change, hopefully go up year by year. It's available online, it's published in the Federal Register. This is just the most recent one that I found for 2019. And it tells you where you can find the regulation that talks about the maximum civil penalty. It tells you how much the penalty is. So if you have no priors, the maximum civil penalty is more than $21,000, which is not nothing, right? So if you're settling a case, you might keep that number in mind as possible exposure for the respondent, right? Even if you're just getting a civil penalty, that's a pretty hefty penalty. Next slide. So punitive damages. I know I'm not super familiar with punitive damages, and I think it's not something that folks are able to try to get every day, but punitive damages, just keep in mind, are meant to punish the respondent or the defendant for their outrageous conduct so that they don't do it again, right? It's not about compensating your client, it's about deterring the respondent from whatever discriminatory act they did. Next slide. So another way to think about it is, did the defendant or the respondent show reckless or callous disregard to the plaintiff's rights? So that basically means they knew what the law was and they broke the law anyway. That's when you're going to look at whether or not punitive damages are available. Next slide. If you're looking at an intentional discrimination case, and again, you're in state or federal court, not in an administrative proceeding, you may expect a punitive damages award, meaning they're common in cases involving intentional discrimination. The size of the defendant or respondent and their financials are relevant because the fine has to be sufficient enough to punish and deter that defendant. And just remember that punitives are not intended to compensate the plaintiff, and the case law basically says that the punitive amount will be upheld unless it shocks the judicial conscience. You can see that Judge Judy there is looking at an unreasonable punitives award. You can go to the next slide. So this is my approach to conciliation. I have never turned down the offer for conciliation. I think it's always a good idea to get a feel for your opposing counsel, the facts that may not support your claim, just to work with your client through the conciliation process. So my approach is to go into a conciliation thinking this is respondent's chance to avoid federal litigation. And if you're conciliating after a cause determination, even more so, right? So conciliation is not a throwaway meeting. You want to be prepared for conciliation. You want to be serious about your settlement demand. You know, that your FAP, your investigating agency, or HUD, they're going to be, you know, looking for relief in the public interest, which they should, right? That's their charge. But you can go farther than that. You need to know what your client wants. You know, your client may not care whether or not respondent gets training, although that will be part of the settlement. They may want, I have a client who wants enough money to buy an accessible van, right? So what your client wants will vary. And when you're in conciliation, you know, you should demand what your client wants to get at the end of the process. Some clients just want training and an apology, although it does seem that getting an apology from respondents can be more difficult than some other things. You know, conciliation is a great opportunity to use the good work of HUD or your investigating agency to resolve the claim quickly for your client before they have to go to federal court, which is going to take at least 2 years, and now who knows how long that would take. So when you walk into conciliation, you really want to be prepared. You want to have authority from your client if they're not going to be there. You want to know what you expect to walk away from the table with. And if you don't settle, you want to know what your plan is, right? If you don't ever plan to file a case in federal court, then that's going to change your analysis in conciliation. You can go to the next slide. So how much is your case worth? It depends. There is no sort of standard answer. It depends on the strength of your claim. So that means, can you prove it, right? How long was your client injured? So did they not have their emotional support animal for 2 weeks, or was it 2 years? Did they face an eviction filing? You know, all sorts of facts determine, you know, how, quote, serious the claim is. Who's your client, right? So I was recently valuing a case. We just set a settlement demand. I found one case with similar facts as far as the violation. It was an emotional support animal case, and it settled for 50 grand. And I thought, well, that's a pretty hefty award in an administrative case for that kind of violation. So I looked, and the plaintiff was a 9/11 first responder and a Navy vet, and on and on. So, you know, he is a very sympathetic plaintiff, and I suspect that that led to a more significant award than you might get in some other instances. So, you know who your client is, know if they're credible on the stand, so that you know what would be reasonable to expect in their case. You also need to know, obviously, where your client is, what court you would be in. If you did have to go to state or federal court, you need to know whether or not you have any evidence of their emotional distress. You know, do they keep a diary? Do they talk to people? Did they have a therapist? Do they have a doctor? And you want to know what a respondent's exposure is, right? So they're on the other side of the table. They're thinking, you know, should we settle this now? How much is this worth? So you want to be able to explain to a respondent why you're going to win, the liability that they're facing, and how much it's going to cost them if they don't settle this case at conciliation. In that red book I talked about on the second slide, the Schwem handbook about fair housing law, there are tables that will tell you recent and older settlements and jury awards in all sorts of fair housing cases, hundreds and hundreds of them. So that is one great resource. There are other case settlement charts floating around, which you can get if you're on the fair housing list. And then there is the DOJ recent accomplishments website, where you can just do a simple word search and look at 5 or 6 recent similar settlements to get an idea of what your case might be worth. But there is nobody who's going to be able to tell you an exact answer to that question. Next slide. So I mentioned attorney's fees a couple times. One thing that's important to know is that a prevailing defendant, so if the defendant wins, if you sue somebody and they win, they're going to get fees against your client only if your claim is frivolous, unreasonable, or groundless, or if you continue to litigate after it clearly became so. So why is that, right? Well, HUD, Congress, the courts, they don't want plaintiffs who have suffered discrimination to not complain, not go to court because they fear a fee award against them. So you know that is a risk. You do need to counsel your client that payment of attorney's fees is a risk if they lose, but the bar as far as prevailing defendants getting fees is pretty high in a fair housing case. You can go to the next slide. So when you're thinking about damages as part of settlement, or if you're in court, the purpose of an award of actual damages is to put the plaintiff in the same position they would have been without the injury. But in a lot of fair housing cases, you're talking about distress, not something you can really fix. So, money is the way that we compensate for that. As far as emotional distress, you don't necessarily have to have an expert. In the Red Book, the Schwem book, there's a long string of cases, which are mostly race discrimination cases, where the courts basically say, all reasonable people understand why that behavior, that racist behavior, would be upsetting and would cause distress. And so you don't need an expert to come and tell anybody that being discriminated against causes distress. You may want an expert depending on your facts. It may be beneficial, but there are cases that settle with emotional distress damages with no expert. You want to know when you're talking about damages and whether you can prove emotional distress. Like I said before, did your client talk to anybody? Do they have a therapist? Do they keep a diary? What evidence do you have to support the causal connection between the defendant's discrimination and your client's distress? So a couple things that you can do to try to prepare yourself to value damages when you're in an administrative proceeding or in court is you can use the emotional distress damages worksheet, which I'm happy to send you, or is in the Red Book. It does a good job of sort of just prompting your client to think about all of the effects that discrimination may have had on them, including loss of sleep, loss of appetite, anger, anxiety. And the worksheet is just a good way to get them thinking about the ways that discrimination may have impacted them, and it's good for you to have a written record of that information. Depending on the client, sometimes I mail it like with a pen and a stamp because you really want that information back from them. Clients have a lot going on. And they may not want to take the time to do that, but it is really important. Also, tell your client to keep notes. So I tell my clients to keep a pad of paper and a pen by their phone. Anybody they talk to about the situation, a call from their manager, maintenance hanging out outside, looking through their window, whatever it is, they need to write it down. When it happened, who did it, how they felt about it. You want to document all of those things contemporaneously if you can. You can go to the next slide. So when you're in conciliation or otherwise, doing some sort of settlement negotiation, these are just some terms that you might want to consider. Obviously not an exhaustive list, but there are some issues that folks don't always think about that they probably should. So obviously you want to think about damages, right? How much is your case worth as far as emotional distress, actual damages, loss of housing opportunity. You want equitable relief, right? So you want your accommodation granted, or whatever equitable relief would be appropriate. You might want the respondent to do some affirmative advertising to undo the harm they've done in the community through their discrimination. Most likely, you're going to want them to get some training so they don't do that to folks again. They'll need to adopt policies depending on what the violation was. If it's an emotional support animal case, they may need to adopt policies or better policies. I generally try to provide what policy I would like to see them have, and I do that by looking at HUD and DOJ's policies and what they have included in their consent decrees, so that I can say, this is the policy we want, and we know that this is a good policy because the Department of Justice wrote this policy. You may want to consider inserting into your settlement that the respondent will not issue what's called a 1099. If you don't know what a 1099 is, you need to look into it. It's a tax form, and I think if you read the form, you'll find that respondent is not required to issue a 1099 just because they pay your client money, and that it's sort of more complex than for this presentation, but I would recommend reading about that and thinking about that. You may want to include attorney's fees in your settlement, and we'll talk about that in just a moment. Confidentiality is not favored for obvious reasons. You know, we want folks to know who the bad guys are doing the bad stuff. And you may want the respondent to display fair housing materials, have, you know, indicia that they don't discriminate on their property. And of course, keep good and contemporaneous time records so that you can talk about fees, which we'll be talking about. And monitoring will always be really a part of your settlement if you're working with HUD or another agency, which is an important part of relief in the public interest. HUD will make sure that the respondent does what they have promised to do. You can go to the next slide. So if you're in court, obviously attorney's fees are awarded by the court, or you would settle while you were in court. But if you're in an administrative proceeding, you know, fees are client driven. That means, you know, you're only going to seek fees if that's what your client wants to do in an administrative proceeding like a HUD proceeding. You should talk to your client early about fees and determine whether or not that's something they want to do. You need to tell them that they're not required, that it's not going to hurt your feelings or make you treat them any differently. If fees are not something that's important to them, some clients don't want to seek fees, which is fine. And some clients think that you are the best lawyer in the world and they want to do everything they can to make sure that you get paid for your effort. You know, that is up to the client. You know, they should also know that respondent is likely to balk at giving fees, especially to a legal aid organization. So if that's something that client is interested in, they need to know that there will come a point when respondent says, I'm willing to pay you complainant, but I'm not going to pay your lawyer. And your client needs to know if they want to take that deal, that is fine. But if they don't, then they can do that as well. So you can never be in conflict with your client. You can never hold up somebody's settlement because of fees. That's completely up to the client in an administrative setting. You can go to the next slide. So folks sometimes don't like to talk about this, but you have got to think about a couple things before you get into the conciliation room or call. In addition to, you know, knowing what your claim is worth and what your client wants and all those things, you need to be thinking about tax implications for your client. So when you get money, it is taxable. So you need to know about your client's income. You need to advise your client early and in writing about tax liability. Now, obviously, you don't know how much you're settling for until it happens, but you don't want to be in a room doing conciliation and end up with more money than perhaps you thought, and then be thinking, oh no, how is this going to impact my client's public benefits, their earned income tax credit, their subsidized housing, their food stamps, their Medicaid. You want to have thought about all of those things before you get into that room. So make sure you know your client's income, all the benefits they receive. Talk to your public benefits attorney if you have one. You know, do some research. In my opinion, it is not enough to tell your client, go seek the advice of a tax professional. They should do that, but I think you have to do more than that so that you can ensure that you know, essentially don't harm your client with their recovery. Okay, now I want to talk just a little bit about substantial equivalency before we go to questions, and I'll be interested to see what folks might want to tell me about this. So substantial equivalency, you know, you heard from HUD. HUD obviously investigates a lot of discrimination cases, but if you live in a jurisdiction that has a substantially equivalent agency, then your case might get referred there. So if you live in Broward or Tampa, your case might get referred by HUD to a FAP to do the investigation. So HUD has to certify those agencies as substantially equivalent. And if you want to look at the regulation 24 CFR 115.200 is where those regulations begin. And what HUD is looking for in those agencies is, are the substantive rights the same that the agency will be investigating? Are their procedures substantially the same? Are the available remedies substantially the same? So can you get the same thing when you're with the local agency in Broward as you can get if your claim was sitting with HUD? And the availability of judicial review. Now you can online, you can easily find the list of substantially equivalent agencies. I have mine on my wall. I count 7, including the Commission on Human Relations. So there aren't that many, but in bigger jurisdictions, you're going to have a local substantially equivalent agency. Next slide. So there have been some issues about substantial equivalency specific to the Commission on Human Relations of late, or sort of late anyway. One problem was that there was some case law in Florida that said you had to exhaust administrative remedies through the Commission on Human Relations or otherwise before you could go to court. Well, the Fair Housing Act doesn't actually say that, and the concern was that that made the Commission on Human Relations not substantially equivalent because the way that the law worked was different according to this case law. So there was legislation, and this language that's on the screen now is from staff analysis of a bill that was very recently passed. You can look at Senate Bill 374 if you want to see draft of the legislation. When I looked, I couldn't tell whether or not the Senate's website was totally updated, but you should be able to read the language of the legislation. Among other things, it specifies that you are not required to exhaust administrative remedies before you go to court in the state of Florida, arguably clearing up that issue about substantial equivalency. But, next slide. The HUD administrative process, if you stay with HUD, you can get actual damages, which includes emotional distress damages. Next slide. And remember that the regulation says that to be substantially equivalent, the Secretary of HUD determines whether the agency provides remedies that are substantially equivalent. Next slide. So the case law in Florida, as far as I can read it, says that administrative agencies do not have the ability to award non-quantifiable damages, like damages for emotional distress, because those awards are a violation of Article 2, Section 3 and Article 1, Section 22 of the Florida Constitution. So the question that I'm pondering, and thanks to Andrea for having me work on this presentation so that I can have this to ponder, is can agencies be substantially equivalent in Florida if the law says that an administrative agency cannot award mental distress damages because it's a violation of the Constitution? So if you know the answer to that question, please do tell me. Otherwise, I will be thinking about that. So I think we have some time for questions, and I know I talk fast, so I am eager to hear if anybody has anything I can help them with or any cases they want to talk about.
Thank you so much, Katherine. Let me check for questions. Thank you to everyone. I've learned so much today. Okay. One person had a question about what is the other name for the red book you mentioned?
So I call it the Schwemm, but let me look it up. So Robert Schwemm well, he's still alive, but he is retired, I think. Fancy lawyer who worked at Kentucky, and let me look it up on my other computer. I think it's called the Housing Discrimination Law and Litigation. Yeah, Housing Discrimination Law and Litigation is what that manual is called. It is pricey, it's not cheap. I think it's one-time purchase right now is $1,200, so it's not nothing, surely. But if you are able to do that, even if you're not able to get the updates in the future, it is really a critical resource. I mean, that's where I go first before I post a question on the listserv so folks can tell me that I'm wrong. I always look in the Schwemm. He has great sample pleadings, sample discovery. If you're going to buy one book to do fair housing, that's probably the book that you want. And I don't get any money for saying that, neither does my organization, but I've been using that since I started. Especially the online version is really easy to navigate, and I find it to be extremely helpful. So if I know the answer to something that you asked me, it's probably because I just looked in that book.
All right, thank you. And when requesting the investigator's final report, do you do a request to produce the final report or a Freedom of Information Act request?
You shouldn't have to do, you should just have to do an email. I mean, if it should not be contentious. At the bottom of your cause or no cause determination, there'll be a little 2 sentences that say, if you want this report, email this place. Sometimes they'll ask you to pay for it, sometimes not. Usually if they can transmit it electronically, they'll just email it to you. I mean, it all has to be compiled anyway because they get reviewed by their bosses and all that. So it should be in a format that can be easily provided. Depending on how long the investigation was, it might be lengthy, how many documents they got from respondent, but you shouldn't have to do a public records request. You should just be able to ask the investigating agency for it.
Okay, great. And how do you prove damages for someone who is avoided housing due to discrimination? I have seen opposing lawyers argue that there are no actual damages because the client would have had to pay rent if they were accepted.
So you may want to use the loss of housing opportunities worksheet, which basically shows the value of the housing. You know, if the housing that you get because you couldn't live where you wanted to is more expensive or is farther from work or is not on the bus line, is farther from your doctor. I mean, there are all kinds of ways that housing, while it may physically be a roof on your head, is not equivalent, right? So you want to think about all of those things. And then of course there's the damage that's just inherent in being discriminated against and then not being able to live where you wanted to live. But you know, I'd struggle to find a situation where the housing that is your second choice is not going to be substantially, significantly different than the housing that was your first choice. So, you know, don't discount what may seem like a little thing. You know, if you're 20 minutes instead of 10 minutes from your kid's school, that's not nothing. You know, that's gas, that's time, that's stress, all of those things. And I had some trouble, Christy, hearing the question. So if that didn't answer the question, please let me know and I'll try again.
Okay. And how can people get the intake spreadsheet you mentioned?
Well, one is from Brancart and Brancart, and I don't know if it's just on their website, but it's not like proprietary or anything. So if you email me, I'll have your email address, and I'm happy to send it to you. Or I'll send, actually, I'll do better. I'll send it to Christy and she can send it to everybody.
Perfect. I will send that out to everybody. Does a no cause determination have an effect in a subsequent court case?
No, absolutely not. It's not going to come in. I mean, I say that just from what I've read. I've not had that come up in my personal experience, but no, it's not going to preclude you. Now, you know, if you get a no cause determination, you know, you may want to think about why that is. But, you know, sometimes administrative agencies are wrong. Sometimes they might not have all the information. Sometimes respondents stonewall, don't give them what they need. But no, you can still go to federal court, you know, if you disagree and you think that your case is good, you can still go to state or federal court. Absolutely. But do think carefully about why you lost.
Okay, we do have a question from Andrea. I wonder if you can object to handling by a substantially equivalent agency if you are seeking emotional distress damages.
Yeah, I don't know, Andrea. You know I don't know. So I don't know. I don't know what we do about that. I think it's a tough question. You know, HUD has been talking to the commission about substantial equivalency since that case came out. I can't remember what that was, but it was maybe 13 years ago. But I don't know yet whether there's something that a private individual can do regarding substantial equivalency. That's, you know, I'm going to dedicate some time to that in the coming weeks because obviously I think it's really critical, but it sounds like it is something that really is out of the commission's hands, out of, you know, it seems like if this is a problem, it seems like it's a constitutional problem. So I don't know what we do about that. But if I figure it out or if somebody knows the answer and just wants to tell me, we can, I'm sure, provide that answer to everybody who's attended the webinar, but I don't know.
Well, thank you for the great presentation. That's all the questions for you as of now. We do have a question that came in for Mr. Barakal. If Mr. Barakal is able to unmute himself, The question is, if the violation is based on a failure of the respondent to provide documents to a claimant in a readable format, for example, to a blind person, how could that person participate fully in the process?
I don't think he's on anymore.
Yes, I'm still on.
There you are.
Repeat the question again, please.
Sure. If the violation is based on a failure of the respondent to provide documents to the claimant in a readable format, i.e. in a Braille format to a blind claimant, how could that person participate fully in the process?
Well, that I would have to check with the investigators because I am not an investigator, so I cannot answer that question, and I don't want to give you false information. So if you provide that question to me, I will get the answer for you.
Thank you. I'll email that to you after the presentation.
All right.
That would be amazing to whoever asked that question, to have a respondent still refusing to provide documents in a readable format in an investigation.
Right. And if anyone comes up with follow-up questions, I'm happy to email them to the presenters. I'll send everyone the link to this recording after the webinar, as well as a link to the Google Drive documents. If you have any trouble accessing them, just email me and let me know. And thank you so much to all of our panelists. They put a lot of time and effort and love into these presentations, and everyone did a fantastic job. So I'm very, very grateful for the time that all of you took on this. And don't forget to register for part 2 of the Nuts and Bolts of Fair Housing. That is next Monday, May 4th from 9 to noon. Got a lot of compliments in the box here. Thank you. Thanks so much for all the good info. You guys rock. So on that note,
Your fair housing questions, they're worth a lot. Don't let anybody tell you they're not.
lots of thank yous there. So thank you all so much. And I will see hopefully most of you next week.